when you try to cover up a conspiracy, to cover up a crime, to cover up a relationship between the current president and his two best friends who were pedophiles and operating a child sex trafficking ring, you run into a lot of issues. And one of them has to do with Donald Trump trying to redefine what the Epstein Files are. We know what they are. They're the 100,000 pages. They're the 300 gigabytes of data that's sitting with Pam Bondi, somebody who was just thrown under the bus by the former Donald Trump Attorney General, Bill Barr, who said in a closed-door deposition to the Oversight Committee, Pam Bondi, you have the power to release all the files. There should be no delay. But Donald Trump keeps trying to do his presidency of distraction and diversion. And the latest one was, let's blame the federal judges who are sitting on the grand jury transcripts. The grand jury transcripts are like 50 pages. They were one day. They were just used to indict Maxwell and Epstein. And now we've got a new ruling from Judge Berman, which we cover at length on the midweek edition of Legal AF, this time with Karen Friedman, Agnifilo, and Dina. And here's a clip.
I want to start with the Epstein case, right? The Epstein Files. When Jeffrey Epstein has been investigated multiple times and was ultimately about to be prosecuted and was prosecuted and arrested. And it was in 2022. And a month after he was arrested and held in jail, he committed suicide. But that was after a lengthy investigation. After he committed suicide, the Department of Justice then prosecuted his co-conspirator, the woman who facilitated and even participated in these sexual assaults against minors, and hundreds of women who have since come forward. And the Justice Department prosecuted Ghislaine Maxwell, and there was a trial, and she was convicted, and she was serving a 20-year sentence. And so to get to the point of prosecution and trial in a federal case, there are just terabytes of discovery of documents, right, of investigatory materials. There are going to be witness interviews. There were search warrants that were executed. There's cell phone records, there's flight records, there's video evidence, there's witness testimony, there's computer evidence that exists. There's the credit card receipts. I mean, I can't tell you how many types of records there are that the Department of Justice will have in order to be able to prosecute cases like this. Thankfully, in this day and age, or not so thankfully, if you're a criminal defense attorney like I am trying to represent people, people leave digital footprints in everything that they do, right? Whether it's video of what you're doing out on the street to your cell phone records and Epstein, because he's a very wealthy person and flew on private planes. There's private plane records, and there are just everywhere you go. You think about your day. It's if you're in New York City, every time you go through the subway, there's a digital record of that. If you're staying in a hotel, every time you go in and out of a hotel room, there's that card reader that leaves a digital footprint. It's like digital breadcrumbs that prosecutors and FBI agents and investigators use to build a case against someone. And that's what they did in the Epstein and Maxwell cases. And all of those records are contained in files that are in the possession of the Department of Justice. We don't even know half of what they have. And the thinnest record, the smallest record that has the least amount of information are grand jury minutes. Grand jury minutes by design are just the bare bones probable cause to charge someone with a crime. And federally, what the prosecutors do is they go into the grand jury. Hearsay is allowed in the grand jury federally, so they typically don't put live witnesses in, and they'll just call an FBI agent or two to essentially summarize the facts and summarize the evidence. And they usually call the FBI agents that they're not going to use at trial so that they can't be cross-examined based on their grand jury testimony. And therefore, that grand jury testimony doesn't have to be turned over to the defense. So you never really get to see federal grand jury records, but they typically, like I said, don't say anything. And we know that's the case in the Epstein case because there have been 3 cases that the Trump administration has brought, 2 in New York, 1 in Florida, basically saying, please release the grand jury minutes. I think that the Trump administration is doing that to kind of say, look, we're making an application to release these grand jury minutes because we see that everybody, bipartisan, Democrats, Republicans, everybody is clamoring for the release of these records of this investigation to find out what is in those files. I mean, don't forget Trump and all of his people surrounding him, including Elon Musk and others, especially leading up to the election, were clamoring for the release of these records and saying, we're going to name names, all of these individuals who were part of this circle of this web of sexual abuse and rape and et cetera, and rapes of children and trafficking. We're going to release all of that because it's not just Epstein alone. It's lots of people, lots of wealthy people, lots of people who we've seen were very close to Jeffrey Epstein, whether it's Prince Andrew, Bill Clinton, Donald Trump, others have all been very close to Jeffrey Epstein. In fact, it's been said that Donald Trump was one of his best friends for many years and flew on his private plane many, many times, including with his children. And so Donald Trump was very much in this, as well as Democrats, Republicans, and other people alike. And Trump and his people were saying, we're going to release these files. And that's been a bipartisan effort to try to do that. And they're the ones in possession of these files, right? Only the grand jury minutes. It's the only thing they need to get permission of the court to release because grand jury minutes are protected by law. They are secret. And there's a very high threshold you have to meet in order to get those released. And to basically allow the Trump administration to blame the judges for saying, oh, we can't release the Epstein files now because the judges won't let us because we can't meet the standard to release the grand jury minutes is actually a fallacy because there's nothing in there. What the meat, the substance, the thing that people want to see is in the possession of the Department of Justice, and they can release it any time. And so we have another federal judge. Why don't you take it from here, Dina, and catch us up to what's happening in the federal courts with these grand jury minutes and what they're saying?
So Judge Berman was the latest judge to deny this request. So Trump is 0 for 3. All 3 district judges have denied his request for the release of the grand jury testimony. And as you say, the most important thing is our grand jury testimony, unlike our other court proceedings, is not meant to be public. This is where the prosecution gets an indictment. You have not yet been indicted. We've always had secrecy around it. And so you have to overcome, there has to be like that compelling interest to overcome in order for the prosecution to kind of request this get released. Somebody who's testified actually could voluntarily on their own testify, but to get the prosecution to get this released when secrecy is like presumed is a high bar. And frankly, Judge Berman has said, you have more. In this particular case, the testimony was from an FBI agent, and there was 70 pages. And he explicitly, the judge in his order, compared those 70 pages to the 100,000 pages that the DOJ has, and really said, come on, like you have so much more than what you're even asking for. You're asking me to break the secrecy for absolutely no reason. It's not as if the only information you have is in this. And to your point, you know, that this isn't the meat of it. It's also really important to say it's not only the meat of it, but clearly the prosecution had the FBI's testimony in their DOJ file. Clearly, the prosecutor had spoken with this FBI person and other FBI agents and knew exactly what this FBI person was going to say. That was the whole reason to put the FBI person in the grand jury because the prosecution was trying to get an indictment. So all of that testimony wasn't like a surprise to the prosecution. It was the whole purpose of putting on that FBI agent because they already knew what the FBI agent was going to say. So it is in the DOJ files. And that was really why the judge in all three cases denied it, because the information can be found elsewhere. It can literally be found in the DOJ's own files. And there is no secrecy, presumption in those DOJ files. The DOJ can do whatever they want with their files. I mean, maybe you have some, you may not want to release like classified information or information about a victim. But in terms of what the FBI told you, you can certainly release it. And that's why this has been really a clear-cut case for all three of the judges.
Yeah, it really is unbelievable to me that, some of the language in Judge Berman's decision, I just want to read. He said, quote, "The government is the logical party to make a comprehensive disclosure to the public of the Epstein files. The grand jury testimony is merely a hearsay snippet of Jeffrey Epstein's alleged conduct." And so, Berman also called out Pam Bondi for essentially reneging on her promises to release the investigatory materials, and basically said that these 70 pages of grand jury materials are a diversion from the scope and breadth of the Epstein files in the government's possession. So, it's really interesting that the judges are they see right through this. All three judges basically called out the DOJ, which is unusual. In my experience, the federal judges historically have always protected the Department of Justice. Criminal defense attorneys in federal court and civil attorneys in federal court going against the Department of Justice, there's a deference and a presumption of regularity, and there's a deference to the Department of Justice and U.S. attorneys' offices because historically, frankly, they have always been the cream of the crop, the best of the best. You tell the truth, you do things without fear or favor. You're honorable. You're these honorable public servants, and judges have always kind of gone along with that. And the judges here are calling out the Justice Department in ways I've never seen before. They're really skeptical and suspicious of the motives of the Department of Justice attorneys, of what they're saying, and of the administration generally. And what the judges are doing is they're essentially saying, you're not going to put this on me. I see what you're doing, Pam Bondi and Donald Trump. You want to blame the court and say, oh, I would have released everything. It's the court who's not doing it. I'm not going to let you do that to me. This is not about the judges. There's nothing here. You have all the information to release. And so the judges are calling out the administration, and rightfully so, because it is I think totally unprecedented, the way this is all coming about. And, we'll see kind of how this plays out. Meanwhile, Congress, there's this other, parallel action happening in Congress where the chairman of the House's Chief Investigative Committee, basically issued subpoenas to the Department of Justice, the oversight, for oversight. This came from Representative James Comer. He's a Republican from Kentucky who issued subpoenas to Pam Bondi after a bipartisan group of representatives essentially teamed up and said, we're going to force the issue. We want these records and we want them to come, and we want them, I think it was by today actually. And that was interesting to see what's going to happen. And it sounds like the administration is going to comply. They're not going to meet today's deadline, but on a rolling basis, I think as soon as Friday, they're going to start releasing heavily redacted documents. Some stuff should be redacted. The victims' identities, for example, should be protected. And but let's see if they will actually produce. They said they needed more time because of the volume. Okay, so let's see if they're going to produce this, and let's see if if the committee then releases this information to the public once they receive it, or if they'll cherry pick it. So that's going to be very interesting. The committee has also started to interview, because they've sent subpoenas to former government officials, and the reporting is that on Monday there was a closed-door deposition with Bill Barr, because he was Trump's AG when Epstein died in jail. So we'll see what that all says. Interestingly, the person who was not subpoenaed is Alex Acosta, and if you remember, Alex Acosta was the Florida prosecutor that gave Epstein a sweetheart deal back in 2007, I believe it was. And a ridiculous deal, actually, where he got a slap on the wrist, essentially, and then immunity from prosecution forever. And him and his co-conspirators, for future immunity from prosecution. Ghislaine Maxwell is trying to use that language to say I had immunity and appeal her case. And Alex Acosta was then promoted by Trump and made to be, a cabinet member. So, but he didn't receive a subpoena yet, which I find very interesting. So what did you take from what's going on in Congress? What do you think? Do you think they're going to release the stuff they get? Do you think they're going to get it? Do you think they're going to release it?
Okay, I'm sorry, but there's no way that a Republican-led committee is actually doing anything here to truly get transparency. This is just another way of delaying, because as we know, they have 100,000 documents. This is going to be, we're going to get a trickle of documents. We're going to get a lot of like the most mundane information. And they're hoping that in like 2 years' time, they're still going to be releasing this and everybody will have forgotten about it. The fact that they act as if the Trump committee needs to subpoena the DOJ in order to get this information tells me everything I need to know. Because Trump controls the DOJ, he controls his Republican committee. If they really wanted transparency, they wouldn't need a subpoena. So this is all a dog and pony show. We're going to get a whole bunch of nothing, and they're going to act just like with the judge and the grand jury that, we're doing this, like, be patient, have time. And, the thing is, if people have been on this story for a very long time, he may be able to, dissuade some people, let's say, who are newer to the story, but there's a whole chunk of people, including a whole chunk of MAGA, that this diversion is not going to work. We're going to, of course, hear Midas and Legal AF, call it out as well, but we're not going to get anything from that subpoena. And it was interesting, evidently the Bill Barr testimony, Comer came out and said something completely different than a Democrat on that committee said that Bill Barr said, and the Democrat called for the release of that transcript. I'll hold my breath of whether or not we get transparency there as well. But that's the other thing. If you're having people speak in private and you're willing to lie to the public about what they say, that doesn't help transparency either. So we're not going to get anything about this unless, like, the public continues to put pressure and maybe there's a leaker. I think maybe that's our best hope, that there's some sort of leaker who's willing to who actually give us transparency here.
My biggest beef with this administration is the fact that they're just they don't tell the truth. I mean, I believe in our democracy so much that I believe that you can disagree on issues and you vote on them. And if there are issues that you disagree with and the majority of people want one thing that you disagree with, everybody has to live with it and vice versa, right? But let's all talk about facts. Let's tell the truth. Let's not live in these alternative realities. And that's the thing that frustrates me the most is, you and I, in preparation for all of these podcasts and all the public speaking that we do, we actually go and do our research. We read the decisions, we read the opinions, we read transcripts. And then when you hear what the Republicans, many of them, but this administration in particular, how they characterize facts that are pretty clear and black and white. They don't tell the truth. And that's what frustrates me the most. And that's the thing that I think is the fuel that runs the engine of Midas Touch, because we're all about trying to get the truth out.
Welcome back. You're on Legal AF YouTube. You knew that. Hit the free subscribe button. That really helps us continue to grow. The other way that helps us, the other fuel for the fire, a fire of resistance, is to come over to Legal AF Substack, where I'm doing 2 lives a day in addition to all the videos and work we do here, bringing together the community, couple of thousand people every time we do a live. It's important. We need subscribers there to continue our rise. I think we're in the top 7 and rising for U.S. politics in all of Substack. And then paid subscribers, I think it's $7 or $8 a month. I'm not trying to be flip or glib, but it is a way to support what we're doing and keep the lights on, so to speak. I'm glad you're here. Legal AF, the podcast, Wednesdays and Saturdays at 8 p.m. Eastern time. Join us there, where I think, because and everything I'm saying is not like an award that I got, like an Oscar. It's a compliment to our audience. I think we're top 20 or top 16 in all YouTube podcasts. That was a clip. If you don't know about Legal AF, the Legal AF, the podcast, Wednesdays and Saturdays at 8 p.m. Eastern time. Saturdays, I do it with Ben Meiselas. Wednesdays, I do it with Karen Friedman Agnifilo. We pull together all the law and politics you need to know at that intersection and bring it to you in a podcast format. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.